I am Bill Rochelle, the columnist for American Bankruptcy Institute. Today, on Rochelle's Daily Wire, video edition, we are going to visit a pair of opinions, one from a bankruptcy judge in Chicago and the other out of the Florida Supreme Court, that tell us, in some circumstances, state law can make a big difference in what a bankruptcy trustee can or cannot do. First, let's go to Chicago with a very interesting case confronting bankruptcy judge Deborah Thorne. In that case, she had a man in bankruptcy who owned real property with his wife as joint tenants with right of survivorship. Before the trustee could sell that jointly owned property, which I think the trustee most certainly could do in most circumstances, unfortunately, the man, the debtor, died. The trustee said, so what? I can still go ahead and sell the property because the interest of the debtor was fixed as of the filing date, and his death makes no difference whatsoever. Judge Thorne comprehensively examined Illinois law and said that in that state, and perhaps elsewhere, when a joint tenant dies with right of survivorship, the entire interest in the property immediately transfers to the survivor. Well, because of that, Judge Thorne said, since the man died, the property in effect zoomed out of the estate and the trustee was left with nothing to sell. The other case comes to us from the 11th Circuit, also with the most important decisions coming with a certified question from the Florida Supreme Court. In this particular case, we're dealing with a UCC-1 financing statement. In this case, the lender had filed a financing statement that abbreviated part of the debtor's name. For instance, let's say that the debtor's name was XYZ Boulevard LLC, with the name Boulevard fully spelled out on the records of the State Secretary of State. But in the financing statement, they wrote it as BLVD. In other words, an abbreviation. Well, to most of us folks, that abbreviation, which clearly means boulevard, would be inconsequential. At worst, a minor error that would not affect the validity of the security interest. But because of some peculiarities under Florida law and perhaps elsewhere, the Florida Supreme Court said that that abbreviated name made the UCC-1 seriously misleading. Get that, the abbreviated name, and it becomes seriously misleading. That forced the 11th Circuit to reverse the two lower courts and hold that the particular security interest was not perfected. I guess what that teaches us is that secured lending is a very specialized area. Don't make any assumptions and only do something if you're dead certain that what you're doing is correct. As I said, I'm Bill Rochelle. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe. Good day.